Patten. Court rise. Appeal in the matter of Commissioners for Her Majesty's Revenue and Customs and Professional Game Match Officials Limited. Lord Head.
Yes, good morning.
Well, good morning. You have identified that we have a solution to the existing problem. It may not be a perfect solution.
Well,
It's quite noisy.
I'm afraid it is really quite noisy, so it'll mean you'll have to keep your voice up.
Well, I'm content to do that, or if need be, we might turn it off for a while.
Either the frying pan into the fire, so to speak, isn't it?
Well, shall we see how we go? And if
Yes.
it becomes difficult to hear me, then
Yes.
we might,
Yes, well, in any event, for the fact that at least we have some aircon, and we're very grateful.
I dealt yesterday with ground 3 and the overarching contract mutuality argument. I dealt also with control and why the Upper Tribunal were wrong to see an error by the first tier.
Yes.
So I'm now going to turn to the role and scope of mutuality and thereby deal with ground 1 and ground 2.
Thank you.
The figures, we had a little debate yesterday and I had misremembered. That figure of just over £500,000 is the gross number made up of the tax and national insurance contributions due if the learned friend is right.
Yes.
But against that has to be set in due course that personal income tax was actually being paid by the referees. So the difference is, will eventually be the employer's national insurance. So in economic terms, this case is about employer's national insurance. And if my learned friend is right, the tax consequences, I say, are to extend the scope of that obligation. And there will also be non-tax, i.e. employment field consequences. But in tax terms, this is just about really the employer's national insurance. And that figure's about half the 500,000. The details don't matter, but I just thought I ought to make that clear.
Sorry, about half of 500,000.
It's about, yes, it's about 250.
So about 250.
About 250.
Thank you. Yes, well, that gives us a feel for the order of magnitude. That's very helpful.
So turning to mutuality itself, we can now see in much sharper focus what my learned friend's case is here. In effect, we now understand my learned friend to say this. The concept of mutuality is designed only to test whether there is a contract, or perhaps a contract somewhere in the employment field. He says that approach is grounded in the authorities, including Uber in the Supreme Court. He then says that the cases that we rely upon are explicable and distinguishable because they are overarching contract cases where the relevant principles are different, or at least apply differently. I say not so on all accounts. My headline response is this: mutuality is designed to have a greater role so as to identify contractual obligations which by their nature are employment obligations. It is correct that mutuality is used in at least two senses in the authorities, but as we shall see, our case is that the right line of authority is that which sees mutuality in this stronger sense, rather than merely the identification of a contract or a contract somewhere in the field. And equally, not all the cases we rely upon can be explained or distinguished as overarching contract cases. I'll show you why that's so, but in any event, the role and scope of mutuality is the same in overarching contract cases as it is in the case of single engagement contracts. There is no difference in the rules, the test, or how you apply those rules. Equally, my learned friend does not find support for his thesis in the Supreme Court in Uber. Before coming to the authorities, I just want to stand back for a moment and think about this as a matter of principle. It is clear from the authorities that this concept of mutuality was originally used as part of the distinction between the status of being an employee and the status of being self-employed or an independent contractor. In more recent times, we have had a third category, that of the worker, someone who is self-employed. Here I interpolate C. Uber at paragraph 38. But that person has some of the attributes of an employee properly so called and gains protection as a worker under the various rights conferred upon him or her by the employment legislation. So there are now three categories. We say in simple terms, an employee or a person is an employee if there are present the right sort of obligations owed both by the alleged employer and the alleged employee. There is then a sufficient framework or degree of control, and the other factors do not require a conclusion that the person is an independent contractor. Now, the notion of a worker is defined differently by statute. I'm not sure you've been shown this yet. There's a lot of discussion in this court and in the authorities of a Lim B worker.
Yeah.
And I think you ought just to see what is a Lim B worker. It's in the first volume of authorities behind tab 3. This is the Employment Rights Act 1996, section 230.
Sorry, which oh yes, the
one,
first,
1, 2, 3.
Yeah.
And the court may well have this in mind, but worker was a concept in effect introduced by a European directive. And UK legislation had to give effect to that concept. And so section 230 defines a worker as an individual who has entered into or works under a contract of employment. So if you're a worker who is a Lim A worker, you are an employee. Or Lim B, any other contract, express or implied, oral or in writing, whereby the individual undertakes to do or perform personally any work or services for another party to the contract, whose status is not by virtue of the contract that of a client or customer of any profession or business undertaking carried on by the individual. So a Lim B worker works under a contract and provides personal work or services to a counterparty where that counterparty is not a client or a customer of a business or profession carried on by the worker.
So that last bit is intended to draw distinction with the self-employed, is that right?
That is designed to draw that boundary.
Yes.
But it a Lim B worker requires you to identify the counterparty, and then to identify whether the worker is providing services to that counterparty other than to someone who is a client or customer of a business.
And well, personally,
And
providing it personally.
has to do so personally.
And X hypothesides not a contract of employment, because if it were, it would come within little a.
My lord, yes.
Yeah.
So, and it's not a contract of employment. Why? Because there's no control, or there's some other provision of the contract that sort of points the other way.
Therein lies the great question which this court may have to determine. Because if you are told that a Lim B worker is not under a contract of employment, does provide personal work in circumstances where it's not pursuant to a business or a profession, you know that's enough to attract Limb B worker status and all the rights that come with it. But you also know, by implication, it's not enough alone to attract employee status. What is left unspoken is what is the touchstone by which then you determine the divide between Limb A and Limb B.
Well, isn't it something to do with the fact that the Limb B definition doesn't say anything about the obligations on the counterpart?
Lady, yes, that is one clear distinction, that a Limb B test looks at the nature of the obligations owed by the alleged worker.
Yeah.
It pays no regard to the nature of the obligations owed by the counterpart. Whereas my submission is going to be that the nature of the obligations owed by both parties is a necessary part of determining whether someone is an employee.
Well, I'm not sure Mr. Norbat would disagree with that.
Well, Mr. Norbat, his submissions as we understand them, is that mutuality is about the existence of a contract at all. So the fact that there are obligations, not the nature of them, or, he puts it more gently, as does the authority, some of the authorities, that it has to be a contract somewhere in the employment field. But if that latter refinement is adopted, still doesn't serve to draw the distinction which we now know is required between Limb A cases and Limb B cases.
But my point...
if you're not considering the worker possibility, you're just looking at it in terms of whether the individual was an employee or not. Wouldn't you get to the consideration of the counterparties' obligations when you came to look at the sort of third issue about looking at all the terms of the contract?
At least at RMC stage 3, my lord, we say yes to that.
Yeah.
But I am going to say that it is also a necessary part of RMC stage 1.
But the whole point of mutuality means that both sides have got obligations, and the question is what obligations do they need to have, isn't it? I don't think Mr. Norbat was suggesting that the counterparty should need to have no obligations, was he?
And that's, I'm not accusing him of that.
No, all right. Well, I just wanted to be clear.
My accusation is that he concentrates on the existence of the obligations and doesn't pay attention until perhaps stage 3 to the nature of those obligations.
I mean, you've got to have obligations on both sides, otherwise it's not a contract.
Otherwise we don't get beyond the question of what is it we're characterising. But if he's right, just to see where I'm ignoring the authorities just for a moment, as a matter of principle, if he's right that you just have to find a contract, or a contract somewhere in the field, but it doesn't require you to determine where in the field, and this is at stage 1, and he says control, sufficient framework of control, he says, and the authorities now largely back him up, that's a rather low hurdle to cross. It's not about actual control, it's about a sufficient framework of control. He then says, and the authorities back him up on this, that at the third stage, you're not asking a neutral, evaluative question. The third stage, you're starting from the footing that it is a contract of employment. you are asking in football terms, is there any reason I can conclude that this is not a goal?
It's a negative.
It's
VAR.
a negative. So in VAR, is there any reason why this is not a goal? It's a loaded question. Now, if my learned friend is right, the first hurdle is met by a contract or a contract somewhere in the field. Second hurdle is crossed in many, maybe nearly all cases there's a sufficient framework of control. And the third question is a skewed evaluative exercise. The effect of that will be to bring many, many more people into the employee field.
It isn't, I mean, you put it as a skewed evaluation exercise, but isn't that inherent to an extent in the way that the third limb of the ready-mix concrete test is phrased?
My lady, the suggestion that the third limb is a negative one
Oh, I see what you mean. But
is grounded in RMC itself
Yeah.
and is made clear by Mr. Justice Briggs as he then was in Weight Watchers. I'll show you.
But actually, when you look at the RMC formulation, it's not phrased as a negative test. It's actually a positive.
Well, the judge actually goes on to say it's negative. I'll
Right.
show you the message in a moment.
Yeah.
It's sort of negative in substance, regardless of the language in which it's expressed.
He actually does use the term negative.
He does use the term, yeah.
And we'll see Mr. Justice Briggs how he puts it in a moment. But we can test, and again, I'm just ignoring the authority. I want to deal with this as a matter of principle.
Yeah.
If I engage a gardener to look after my garden, and I tell him what to do and when, I provide the materials, the plants, whatever it may be, and I'm particular about the hours he works and how he tidies up, there may well be a sufficient framework of control. I have engaged him, the contract may be written, it may be oral. That puts him somewhere in the employment field. And then at the third stage, I start by saying, well, I must assume you look like an employee. I'm now asking for reasons as to why I can conclude that you're not. And given that third stage is skewed, it's not a neutral evaluation, there is a grave danger that the category of employee is vastly increased to cover those who would not dream of being an employee, and in this case would cause the tax field, would cause people to be taxed as employees, even if they had not hitherto enjoyed any of the employment protections of being an employee. Now, I accept that this is a debate about principle and of what the answer ought to be, and you may well conclude that you are driven to that conclusion by the authorities. But I do say, given the consequences of my own friend's argument and what it does to the divide between employee and limb B worker, I'll have a little more to say about that in due course. Given the consequences of his argument, you should only accept my learned friend's thesis as to how mutuality is to be understood if you are driven to it by the authorities. I'm going to show you why that's not the case.
And just, sorry, just remind me when you speak up, what turns on this question of how broad the inquiry under the first head of mutuality is for the purposes of this appeal? I'm now talking about the individual contract, which is what you're coming on to deal with.
The first tier said that there wasn't the requisite mutuality.
Yes, right.
And if I'm wrong about control, I have to rely on that. The Upper Tribunal blessed that conclusion.
Said it couldn't be overturned as a matter of law.
Yes.
Yeah.
And if I'm wrong about my submissions this morning, then the individual contracts were contracts of employment, and the the vast bulk of the money received by referees is paid under the individual engagements. And so the tax that has been assessed on my clients was definitely.
I'm sorry, I thought you still had your control argument.
I'm assuming, my Lord, I'm assuming, in answer to my Lord's question, that if I lose the control argument.
Oh, right, yes.
My Lord, I think had asked me what's the consequence on mutuality. If I lose the control argument, that is the consequence. If I'm right about control, then I have a second reason why this is not a contract of employment.
Yep.
But the wider consequence of this case, wider consequences, at least potential consequences, do need to be borne in mind, because you are being asked to tread on or very near the dividing line between a Limb A worker and a Limb B worker. And when we come to look at the authorities, some of the authorities are about employment status properly so called, are you an employee? Some of them, indeed many of the more recent ones, are about workers. So one needs to bear in mind which fight are we looking at in a given authority. But also we need to bear in mind the subtle but important distinction that Parliament has drawn in section 230 between Limb A and Limb B.
I mean, in simple terms, a contract of employment is a subset of worker in the parliamentary definition.
It is. It is. But, yes, my Lord, that is right. That is right.
Yeah.
But the parliamentary drafter has assumed, in the way that 233 is laid out, there is somewhere a hard-edged legal conceptual divide between category A and category B.
Well, that's one way of looking at it. Another way might be to say it's just, the boundary might be, so to speak, acknowledged to be a rather fluid and difficult one to draw, but in order to widen the net, you have Limb B as well as Limb A, and it doesn't particularly matter where you draw the line, as long as you come within one or the other.
Well, Lord, it does, I'm afraid it does matter.
Well, why not? You'll need to explain why it matters.
Well, two reasons. In the tax field, PAY income tax, employment tax, is due from Limb A,
Yes.
but not from Limb B.
Yeah.
And in the employment field, the employment protection, the rights conferred by various statutory provisions, are better and greater if you're Limb A than Limb B.
Yeah. Yes.
So I'm afraid it does matter. Your Lordship may well be right that this is a rather difficult boundary to identify. But
Surely the key question in the cases where it matters is whether there's a contract of employment. And in the cases where it doesn't matter, where the protection is conferred on workers generally, so for example discrimination, then the only issue is whether you're a worker or not.
My lady, that is right, but that rather serves to emphasise that different rights and indeed different obligations for employers are present depending on whether you're a Limb A case or a Limb B case.
Well, that's hardly surprising. I mean, that's the nature of the... You wouldn't have these concepts if they didn't have different consequences. But I mean, we're dealing with a tax case, and the issue is simply, is this a contract of employment or not?
Yes.
So whether it might also, arguably... no, sorry, forget that. I mean, that surely is the only question.
Just so that your court can be clear, I am not suggesting here that this is a tax fight about the status of workers. The only issue here is contract of employment, yes or no. But in looking at the authorities and bearing in mind what is said to be the relevance and role of mutuality, you do need to bear in mind whether you're looking at a worker case or an employee case, and you do need to bear in mind that Parliament has drawn this
Yes.
admittedly difficult boundary.
I mean, I fully accept that. And so we need, as you say, we need to be very careful in looking at any authority to be sure which type of status is an issue.
Well, yes. But let me then turn to the authorities, principle aside. I'm afraid we do need to start with ready-mix concrete. I appreciate you've seen this from my learned friend Mr. Latimer is now possibly the most famous concrete deliverer in the UK. Can we just note, if I leave you at some stage to read the head note, but the contract that Mr. Latimer signed was for 5 years. It was a 5-year contract under which he was described as an independent contractor. He was paid a mileage rate. He paid for his own delivery lorry and the expenses. He had the license. He had to maintain and insure the truck. He had a limited ability to use a substitute. He was required to wear RMC uniform and abide by company rules. You get that from the head note and from the facts as found by the Minister of Social Security at 499 in the report, numbered paragraph 1 through 501 to significantly down to 503. And the fact that it's a 5-year contract is at 501 letter E. So against that background, the judge's judgment starts at 508. Can we just note, as we go past 510, clause 5 of the agreement, letter D. This was the obligation on Mr. Latimer to make his truck and himself available to deliver concrete. And then over the page, 511 at letter C, the judge identifies that Mr. Latimer had a limited right of substitution. And then at letter E and F on 511, the judge identifies that he was required to carry out all reasonable orders as if he were an employee of the company, including speed and manner in which he operates the truck. And the truck has to be freshly painted in the colours and the signs directed by the company. So with those facts in mind, picking the judgment up at 515, there is now the famous passage beginning at letter C, where the judge identifies the 3 limbs. But in Roman 1, limb 1, he is looking not just at the existence of the obligation, but he is looking at the nature of that obligation. And then limb 2 is control, and then 3, consistency. And then at letter E on 515, he rightly observes that if there's no contract, then the argument doesn't get off the ground, there's nothing to characterise. But once you have a contract, then you need to look at the nature of the obligations in that contract. Then he deals with control, which we saw from a learned friend yesterday in the Acrobat case. And then over the page at 516, letter B, the third and negative condition. So that's where he describes it as a negative condition. He gives examples. Now what's interesting is in his negative condition, the examples he gives seek to understand the nature of the obligations that are imposed on the alleged employee. The detail perhaps doesn't matter, but he concludes in effect that if you're contracted to build, it's it's a building contract, not an employee contract. Or if you're contracted to carry, it's a contract of carriage and not an employment contract, and so on. So that third stage is looking at the nature of the obligations, and that's reiterated at the top of 517 between letters A and B. If the provisions of the contract as a whole are inconsistent with it being a contract of services, it will be some other kind of contract. Now, just putting that, this is not a statute, nor is it simply a checklist or a checkbox exercise that can necessarily be reduced to a flowchart. What His Lordship has in mind in this case is a series of elements to the test, which he's suggesting are applied in a particular order. He's not laying down anything more definitive than that. And then when he goes on to actually answer this case, i.e. provide his conclusion, we turn on to 525 in the report, letter F. It is now time to state my conclusion. And he said it's not an employment contract, it's a contract of carriage. And then from letter G at 525 down to letter G at 526, His Lordship identifies factors that have driven him to that conclusion, but they are factors that relate both to whether it could be said Mr. Latimer was in business on his own account. That's a stage 3 consideration. But equally, the degree of control which the alleged employer, RMC here, had over Mr. Latimer. So there are factors at letter C and D in 526 that address the degree of control. It's too simplistic to say that ready mixed concrete itself is a case that only turns on the third level. There is discussion in the operative part of his decision about the second and third levels. So of course it's going to bear careful study when you come to consider this case, but it's not a statute. And what the judge does at the end of his exercise is to stand back and look at all of the relevant factors that might bear on the status of Mr. Latimer. Now, immediately after the decision in RMC, there were at least two relevant uncertainties. The first of those was, is this RMC test the only relevant test? And the second uncertainty is, well, what does mutuality of obligation mean in different types of case? Now, as regards that first uncertainty, you were shown by my learned friend market investigations, and that's behind tab 9. You just need to note that ready mixed concrete was decided on the 8th of December 1967. And then market investigations was decided in the summer of 1968. So we're about 6-7 months on in time. And in market investigations, the judge uses his primary touchstone to divide employment from self-employment, this notion of being in business on one's own account. And he does that, Mr. Justice Cook, because he recognises that control is not a particularly helpful factor. That's at 183 letter D. And it's not particularly helpful because there are now lots of people who are providing work-related services whom you don't actually control on a day-to-day basis. So what Mr. Justice Cook said, well, given that control is a difficult criterion, I'm going to ask myself was he in business on his own account, which he believes is the fundamental test, and that phrase is at 184 between letters G and H. And he gets that from an earlier decision of Lord Justice Denning and from the Supreme Court of Australia, because so between letters G and H, the fundamental test to be applied is, in effect, is he in business on his own account. Now, whether that was a departure from RMC orthodoxy, or whether it represented just another test, was unclear for a while at least. Can I just invite you to turn on to tab 11, the decision of this court, which I shall need briefly to come back to. It's a case called Nethermere and Gardner. We're now on in 1984, where this court says that in effect to describe business on own account as the fundamental test is to put the point too high. And one can see that in the judgment of Lord Justice Stevenson at 619.
I'm sorry, which tab is it?
We're in tab 11, and it should be Nethermere and Gardner.
Yes.
Yeah.
And can I just invite you to note at this point, 619 letter G, the conclusion below adopted what Cook, Justice Cook had said in Market Investigation and called the fundamental test. And Lord Justice Stevenson says just above letter H, I think it's misleading to describe it as the fundamental test, for it is no more than a useful test. Now, this court has also had a couple of other things to say about the significance of the RMC test itself. Is it the only test? In a couple of other cases. So can I invite you to turn on to Montgomery, which is at tab 18. Montgomery and Johnson Underwood. And this is Mr. Justice Buckley sitting in the Court of Appeal. Can I just invite you quickly to read paragraph 23, begins 825 of the report, just over the page at the top of 826. And in that, Lord Justice Longmore and Lord Justice Brooke agree. Paragraphs 45 and 47. So just pausing there, ready-mixed concrete identified three-limbed test. Almost immediately in market investigations, a different test was suggested. It was said to be fundamental. That is then later in Nethermere later said to be not a fundamental test, just another test. And Montgomery harks back to RMC and says both that it is a good and useful test and one that should be applied.
But it's not quite right to characterise, I mean, to say that there's a big difference between market investigations and ready-mix concrete, because after all, Mr. Justice McKenna did ask himself in ready-mix concrete whether the driver was in business on his own account.
Milady, I accept that and endorse it, but there was a school of thought for a while that market investigation was suggesting that business on own account was the test, or the fundamental test. The authorities later identified that as not. Now, all of this in a sense is moot, because in Uber, very recently, the Supreme Court blessed ready-mixed concrete. I'll show you that when we get there. When one looks at the sweep of the authorities between 1968 and 2021, certainly in the earlier periods, you will find authorities that don't apply ready-mixed concrete in the way that it is now understood, sometimes don't apply it in a sense at all because they focus on some other test. But what we're told very recently in Uber is that ready-mixed concrete is the fountain. So that first uncertainty that rumbled around for quite a long time should now be settled. The second uncertainty, what does mutuality of obligation mean and how should it be applied in different cases, recognises that mutuality has been used in some of the authorities to identify whether there's a contract at all. Absent contract, there's nothing to characterise. Equally, the authorities have been it's been used in the authorities to determine whether there's a contract with the right counterparty. Now, you'll recall there are tripartite or agency cases where sometimes it's necessary for the person complaining about their employment treatment to establish that they have a contract with the party against whom they make a claim. And in those tripartite cases, the argument sometimes is there a contract of any sort at all? Or in some of the cases, is it a contract with the right counterparty? And quasi can be analysed in that way, because the dancer brought a claim against Stringfellows, with whom she had a contract, and her contract was to pay Stringfellows for the right to dance. She was actually paid by the customers of Stringfellows. You can think of that as being another tripartite case, although it's not quite the same conceptually as the agency cases. But in quasi, again the argument is, does she have a contract with the person against whom she is seeking relief? But one does need to bear in mind when looking at the authorities that we may be asking a question, is there a contract? Or is there a contract with the right counterparty? Or equally, is there the right sort of contract? And that's put into stark relief in modern times by the fact that there are now more frequently seen people working under a series of individual engagements, so-called gig economy. And in that more modern field, it is possible that they only have single engagements. Equally, it's possible that they have an umbrella contract that sits, an overarching contract that sits over those single engagements. But if, and pausing there, if I am a disgruntled, I'll have to use the term worker, I can't think of a different one. If I'm a disgruntled worker and I am seeking some kind of employment right or protection, it doesn't matter to me in principle whether I get home on the overarching contract or the individual contract, provided I can get the relief I seek under the relevant contract. So you will often see these cases where an argument is run about the nature of the overarching contract and then the individual contract. But if you are required to test each category of contract, and you are going to use ready-mixed concrete, thereby necessarily using this concept of mutuality, that concept is the same in principle whether you are testing the individual contract or the overarching. It's not a different concept, it's not a different test. To ram that point home perhaps unnecessarily, it's not said in the authorities there's a particular type of RMC analysis that is appropriate to individual contracts and a different type of RMC analysis that is appropriate to overarching contracts. Here, obviously, we're only concerned with the individual contracts, because if you're with me, the submissions I made yesterday, the first tier was right to conclude that there was no mutuality in the overarching. Now, pausing there is now recognition in the authorities of the different circumstances in which mutuality can be tested. And here I think I need to show you two authorities and then the upper tribunal below. The first authority is, in my bundle at least, is the last case of bundle 1, tab 23, and that's Cotswold. Now the paragraph that's particularly relevant to where I am at the moment in my submissions is paragraph 19. But to save me coming back to this case in a little while, can I invite you, I think we looked at this yesterday, at least at the head note in some parts of it with my own friend. Mr. Williams was engaged by Cotswold Developments to work as a carpenter on work that Cotswold's Development was subcontracted to do by the London Underground. It's the first 4 lines under the facts, and he had no written contract. So then he was dismissed, and he brought a claim for unfair and wrongful dismissal and non-payment of holiday pay. That raised the question as to whether he might be an employee or a worker. And then at left-hand column, second hole punch, the tribunal found that Mr. Williams worked regularly for Cotswold throughout the 21 months of his engagement, and there was no suggestion that he'd worked for anyone else during that period. So the nature of the work he did is recorded in that paragraph. And then the held in the right-hand column, we've seen, so over the page, Mr. Justice Langstaff begins in that right-hand column, sets out the underlying facts. And then over the page 295 of the bundle, paragraph 12, he has a heading, the law. And he begins rather presently, hallowed by repetition in case law though they may be, the words mutuality of obligation do not appear in any statute. And he sets out section 230, and then at 16 he identifies ready-mixed concrete,
And this is a case where the question of whether he was an employee and therefore whether there was mutuality of obligation was critical to whether he could bring claims for unfair dismissal.
My lord, yes, he ran an argument that
Because he lost that on that point in the tribunal.
in the employment tribunal, they said he was a worker but not an employee, and the EAT allows both appeals and sends it back.
So, I mean, but that's the context in which the mutuality issue arises, i.e. is he an employee for purposes of bringing that claim?
My lord, yes. Can I invite you to read paragraphs 19 and 20?
Yes.
Yeah.
At some stage, I anticipate you will likely want to come back and see what he says in 21, 22 and 23, because it's there dealing with the authorities up to that point chronologically. In the interest of time, if I can just invite you to mark those paragraphs so you can see what he does say. But then, moving on so I don't have to come back to this case, 25 is the submissions of the parties in overview, and then 31 and 38 are their submissions in more detail, and he begins his discussion at 40. Can I invite you to read paragraph 40? And then in 41 he mentions a case called Cavill and Barrett. And in 42, I know we don't need 42, it's 40, you were shown by my friend 49.
Yes.
Can I invite you just to read quickly 47 and 48? and you were shown 49, and then lastly, it's I'm afraid quite long, but 54 and 55 are particularly important. If I invite you quickly to read those. Yeah. Relevantly for my purposes, he's making 2 points. The first is that this concept of mutuality is used in different senses in different authorities. And secondly, he's making the point I want to go on to develop, that he thinks it ought to be understood in this stronger sense of requiring obligations of particular nature.
Does one need to bear in mind that this is an overarching contract case?
Well, Milady, it's harking back to a point I made a few moments ago. Ultimately, whether you're looking at a contract that is an overarching contract or an individual engagement case, the concept of mutuality is the same. The test as to the nature of that contract should be the same. But one does need to bear in mind when performing a very close reading of the authorities as to what was going on in a given case.
So your submission really is that it doesn't matter whether it's an individual contract case or an overarching contract case, the requirements are the same. Is that your submission?
The requirements of mutuality should be the same, yes.
Should be or are?
I say should be and are the authorities.
Right.
I want to come back and show you a slightly longer sweep of authority about the substantive point, what is the nature of this concept. But I stopped at that case to make the point that it is now recognised in the authorities that mutuality is used in different senses in different cases. And just to bring that more up to date, there's the Weight Watchers case, which is behind tab 32 in volume 2. Mr. Justice Briggs, as he then was, dealing with a tax and national insurance case in the Upper Tribunal. Tab 32, page 426 of the bundle. For your note, can I invite you at some stage to read paragraphs 22 all the way to 32? But for now, can I just invite you to read 22? Sorry, 22 and 23.
Yes. Yeah.
And to save me coming back to the case, it's a slightly different point. If one turns on to paragraphs 41 and 42, it's here that His Lordship emphasises that the third stage of ready-mix concrete is a negative condition. So one can see that 3 lines down in 41 by reference to the judge in RMC. And then at 42, which Justice Briggs says this, putting it more broadly, where it is shown in relation to a particular contract that there exists both the requisite mutuality of work-related obligation and the requisite degree of control, and it will prima facie be a contract of employment unless, viewed as a whole, there is something about the terms which places it in some different category. And he goes on to say, in effect, this is not an even balancing exercise, it's a skewed one. Because your starting point is that it's a contract of employment, unless there's a reason to conclude otherwise.
So, I mean, is it that, I mean, it seems to be, I think what you're saying is that the third stage can't really comprehend the sort of exercise that needs to be undertaken to identify this contract of employment. Because you're really asking a different question when you get to that stage. You're not trying to apply or to identify what are the critical, the irreducible minimum in terms of what obligations there have to be for it to be a contract of employment. We're just simply looking at that point, assuming it's ticked the first 2 boxes, mutuality and control, to see whether the other provisions of the contract, or perhaps all the provisions of the contract, are compatible with and or not inconsistent with the decision or the analysis you've reached in answering the first 2 questions.
That is exactly it, yes. It doesn't allow you to ask a sufficiently sophisticated question at that third stage to compensate, if my learned friend is right, for not having asked that question at the first stage. Now, the difficulty with all these authorities, we had exactly this debate in front of the Upper Tribunal. And the Upper Tribunal heard this debate, looked at all of these authorities, and went away and produced its own analysis, which is both a summary and a synthesis. And my starting point in this court is that summary and synthesis was right as a matter of law. And the content doesn't matter just yet. But if I can just show you what the Upper Tribunal did, so that you can see that they did the exercise you're being asked to do. So in the Upper Tribunal decision, there's a heading, it's the heading that's right at the foot of page 91 of the bundle, page 11 of the print. It's heading Mutuality of Obligation. And then substantively it begins with paragraph 36 of page 12. We've seen this with my learned friend, but 36 they encapsulated two questions they had to ask themselves and answer. And then under the heading, the relevance of mutuality of obligation, from 37 through to 49, they look at the authorities and arrive at a conclusion in 49. So they initially reject one of the learned friend's contentions. Then under the next heading, the content of the mutual obligations, paragraph 50 onwards, they seek to understand what the authorities require must be the content of those obligations. And they start with ready-mix concrete, they look at Clark and Nethermere and all the authorities I'm afraid I'm going to show you in a moment. But from 50 through to 66, they do that exercise of seeking to analyse, summarise and synthesise the state of the authorities. And then from 67, they identify particularly important propositions that they draw from that analysis of the authorities. That's 68 through to 70. Of course, given that it's an appeal from the Upper Tribunal, their decision bears careful consideration. The exercise they've done here bears particularly careful consideration because it is in effect the exercise you are being asked to do. So what the learned friend has to persuade you is that they've made some error of law in that exercise. Now the other uncertainty that was not clear until relatively recently on the authorities was the significance, or otherwise, of the fact that there may be particular types of obligation in an umbrella contract when one came to judge the status of individual contracts, i.e., to what extent does the nature of an umbrella contract cast light on the nature of an individual contract. And it had been suggested in the authorities that one should not be a material factor in judging the other. And Lord Justice Underhill addressed that in Windle, and that's also in the second volume of authorities at tab 40. And these were the interpreters who worked on an engagement by engagement basis. And the question was, were they workers? But it's Lord Justice Underhill, paragraph, he has a heading at page 532 of the bundle, paragraph 21, the appeal.
So there was no issue in this case about whether they were employees because they weren't claiming to be employees. The only question was whether they were workers and so protected as workers. I mean, that's pretty clear from the head note, isn't it?
Yes, because the claimants had accepted that they were not employed under a Lim A contract of employment. And you can see that at letter F in the head note on page 568 of the report. And the Employment Tribunal had decided that there was no umbrella contract operating between assignments, no mutuality of obligation, and no relationship of subordination. So the Employment Tribunal had said that they were not workers. And that conclusion is ultimately what this court upholds. But in this court, the appeal was rather narrow, so could I invite you to read quickly paragraphs 21 to 23, page 578 of the report. So what his lordship is saying there is that the absence of mutual obligations outside the individual engagements may shed light on the character of the relationship during the individual engagements. It's not saying that it will, but that it may.
Yeah.
And that's an observation that in effect he repeated, or just as Underhill repeated in Pimlico Plumbers. Just for your note, it's volume 2, tab 41, paragraph 145.
I'm so sorry, could you just give that reference again, please?
Pimlico Plumbers in the Court of Appeal, tab 2, so volume 2, tab 41, paragraph 145.
Thank you.
But we then need to see what happened very recently in Uber, which is in volume 3.
I mean, does this really amount to more than what seems to me a fairly obvious proposition? If you're looking at individual assignments in a series, I mean, you have to put them in their context, and before you can sensibly draw a conclusion about their correct classification.
Well, yes. And one might think one doesn't need authority for that proposition.
I hope that was obvious. Anyway,
Now, let me show you, my lord, why it wasn't apparently obvious, but now is.
of course, yeah.
So volume 3, tab 55.
Sorry, is this Uber we're going
This
to
is
now?
Uber.
Yes.
Your lordship will forgive me, I've currently just lost the paragraph reference.
Would it be 91 you're looking for?
My lord, yes, it's 91. I'm afraid I'd skipped over that. the reason why it might not have been obvious is what Mr. Justice Elias had said in James and Redcap Browns.
Yeah.
So picking it up in 91, but at letter F in the quote from Redcap, Mr. Justice Elias had said, there is no reason in logic or justice why the lack of worker status in the gaps should have any bearing on the status when working. Slightly unattractive or unhelpful feature here, but Lord Legate says, letter G, I agree. He says, I agree, subject only to the qualification, where an individual only works intermittently or on a casual basis for another person, that may, depending on the facts, tend to indicate a degree of independence or lack of subordination in the relationship while at work, which is incompatible with worker status. See Windle at paragraph 23. We take from that that the Supreme Court were agreeing with Lord Justice Underhill in Windle and qualifying what Mr. Justice Elias had said in Redcap. So here, to take my Lord's observation, if, as the first tier held and the upper tier upheld, there is no mutuality in the overarching contracts, then that is a relevant factor in determining the nature of the individual contracts. But that is a factor that comes in at stage 1 in looking at the nature of the obligations, not merely at stage 3.
I mean, we're presumably heading, Mr. Peacock. I mean, one can see it in paragraph 91 here, to what may be the critical issue in relation to the individual contracts, which is whether you can, whether and if so, how, into a contract of a series of individual signs, you can find on the employer's side, if this is on the hypothesis that you're saying it is a contract, the obligation to provide work. Because this is, I mean, the Upper Tribunal in the paragraphs we looked at yesterday and you referred to, said that was what was missing, and that was something which was required to be there in terms of mutuality.
In circumstances where the individual engagement starts at the point of acceptance on the say Tuesday, ends with the final report on the Saturday or the Sunday.
Exactly. I mean,
in circumstances where, in effect, either side can change their mind.
I mean, in a situation where you haven't got an overarching contract to make good the absence of an obligation to provide work in the individual contract.
Yes. So we become the case where the relevant features to be tested when you're looking at the nature of the individual contract obligations is that there's no obligation to offer a match or to accept one, and even when one is offered and accepted, PGMOL can change their mind, do from time to time, and the referee can change his mind for whatever reason without sanction, and they do change their mind. They don't always take the appointments they initially accept. They don't always take up those because work gets in the way, family life gets in the way, illness, injury, travel, all the reasons.
I mean, in the case of the individual contract, the employer's obligation to provide work, I mean, has that got to be an obligation to provide that work, i.e. the particular assignment? Has it got to be no more than that? Or has it got to be something wider?
But if it has to be something wider than that, conventional analysis would suggest you'd look somewhere in the overarching contract.
Right.
But if it's just an obligation to offer this appointment, this gig, then, and we're only looking now, let's assume, at the individual engagements, that is absent here.
Well, there's no obligation to offer the opportunity of refereeing at the match, but once there's been offer and acceptance for a particular match, subject to the point about either side having a contractual right to pull out, why isn't there an obligation on PGMOL to let the referee them again?
Because PGMOL has in effect reserved to itself the ability to say, well, we've changed our minds.
Well, I park that because that's a term of the contract.
I appreciate that there's a conceptual question if we leave that out of account, out of one analysis. But my answer, I'm afraid, has to be you can't leave it out of account.
Yeah. So in other words, you're saying that the way that it was analysed is right, and Mr. Norbat's submission that that's an irrelevant consideration is wrong. That's your approach to that.
It's a relevant consideration that has to be addressed when looking at the nature of the obligations.
But do I sense that if you park those contractual rights, you don't have a fallback?
Well, my fallback, my lady, is this, that if you ignore that feature and you only rely on the fact that there was offer and acceptance, and in due course, because the referee does work, therefore he is paid, therefore there's something that might be taxable, that doesn't serve to distinguish a contract of employment from a contract by which I might engage my independent contractor gardener. The fact of the contract and the fact that the work is done then does not provide a discriminating feature which would separate independent contractors from employees.
All right.
Now, it may well be that this is a very unusual sort of contract that is the product of the referee's enthusiasm to referee. And there's certainly no authority that looks like this, but certainly I'm aware of.
Is it right that the stage 1 test has to provide a distinction between employees and the self-employed? I mean, why can that not be the ultimate conclusion you reach, having gone on to stages 2 and 3?
My lord, ready-mix concrete does not only have one link.
No, not precisely. So why is it a problem if the formulation that Mr. Norbat has been putting to us doesn't in itself discriminate in all cases at stage 1 between contracts of employment and ones of self-employment?
Because he goes on to say, I'll paraphrase for him, control's a very low hurdle, you just have a sufficient framework of control.
Yes.
And at stage 3, it's not a neutral weighing exercise, it's a skewed exercise that doesn't allow or doesn't adequately allow you to look at the nature of the obligations.
I'd be saying that's precisely when you do look at the nature of the obligations. I mean, as in ready mixed itself, where it turns out to be a contract of carriage after all.
But in those circumstances, my lord, the authorities now, and certainly in light of Weight Watchers, don't allow you to ask the intellectually neutral question of is this a contract of employment or not. You start with the conclusion that prima facie it is.
Yes, but there may be a series of features that show you that it isn't, as in ready-mix concrete.
Well, as in this case, because ultimately
Yeah.
what the first tier do is they look at the nature of the obligations.
But except that the first year, when they applied stage 3, it said, you know, some of the features are a bit consistent with it.
Well, but they, quite rightly, the first tier say some things point one way, some things point another. But in Mrs. Justice Thorpe's paragraphs 170 to 174, that third stage, one wants to analyse what she was doing by saying that she looked at the nature of the obligations at that third stage. He is saying there is not the right sort of obligation when looked at, even with all the other factors, for this to be a contract of employment. And if that's the right way analytically to approach this, then it is all down to the first tier to do that weighing exercise, looking at all the circumstances, which the judge has told us to do in RMC, and then my ultimate fallback is to say, well, what's wrong with the weighing exercise that the judge in the first tier did?
Because in your Gardner example, there's a wage work bargain, but I mean, I know you said that some people control gardeners, but generally speaking, there isn't much control. And at the third stage, the gardener goes around and does work for all sorts of people. So, if you apply the 3 stages to the gardener,
that might be right if I employ a gardener from local gardener services and he's got a van and a website and a business card. If I engage old Mr. Smith from the village who comes and pots around my garden for 3 hours a week, and I'm his only client, I have a contract.
well, you might have a problem.
But that might be right, but one needs to understand that the consequences of a conclusion, in this case in my learned friend's favour, is that people like that are, or may very well be, employees.
Well, I don't find that a startling proposition necessarily. I mean, PAYE won't apply because you'd be well under any relevant threshold. So what does it matter?
I'm not sure that's right, my lord. PAYE would apply, I think.
Would it? I'm not up to date with the latest figures, but I thought the sort of sum you'd be paying a casual jobbing gardener for a couple of hours' work would not trigger any obligation.
I don't think that's right. I think the problem has arisen most commonly where people employ nannies or au pairs.
Well, absolutely. And there you're paying a much higher wage for
But also
a pretty
a
much
nanny-
full-time job.
Yeah, nanny is a sort of prime example of an employee.
Yes.
But if it's said against me, I think it is, that why don't we just leave all the heavy lifting to stage 3, notwithstanding that it's a skewed test. I'm going to show you that that's not right as a matter of authority. That's ignore the authority for the moment. The difficulty is it doesn't allow the right sort of analysis at stage 3. But in any event here, my own friend still has to persuade you that the first tier made some error of law in the exercise that it conducted, looking at limbs 1 and 3 together. So let me put aside control. Another way of putting it, it doesn't matter whether you take mutuality of obligation, the nature of the obligations into account at stage 1 or at stage 3, as long as you take it into account in one of them.
Yeah. Well, I find that a much more, perhaps to me, a more attractive way of looking at it. I mean, since this is not a statute we're construing, I have an instinctive aversion to being too rigid about what has to be done at each stage. As long as it all feeds into the ultimate multifactorial assessment.
I have maybe it's a personal bugbear that RMC shouldn't be understood in that skewed way at the third stage, but accepting that I'm bound by that, if the effect of the Lordship's observation is that the nature of the obligations is weighed, whether at stage 1 or at stage 3, in the present case, that is an exercise the first tier have done.
Yes, well, that I can follow. I mean, in a way, that would also tally with the approach one's always being told in the latest authorities to adopt of any form of contractual interpretation. It's a sort of iterative process, and it doesn't much matter where you start as long as you go through the necessary steps before reaching your ultimate conclusion.
Yes.
I mean, the reality is that the fact-finding tribunal will first of all have to decide what the terms of the contract were, whether they were all simply in one document or a document partly or whatever the case may be.
So in a way, that will result in them having in front of them all the terms as found in the contract, and so that even if they go 1, 2, 3, I mean they're going to approach stage 1 with all the terms very much in focus, having determined what the actual nature of terms of the arrangement are.
And as my Lord says, in a sense, whether they do it at stage 1 or at stage 3,
Yeah.
it may not matter. But for my part, as long as they do it.
Yeah.
Now there is.
But I mean, are we going to be asked to decide what this court decided in the Cornwall case?
There is, I'm afraid, an exercise that I might have to do, which is to look at these authorities. You do need to read them chronologically. You then need to work out what did they actually decide, and does it bear on the point of principle. And that's not an attractive exercise. It's not necessarily a fruitful one. But if you want to see how the authorities have developed, I'm afraid it's one I have to do.
And that's why we have 3 days allowed for this appeal.
Well, let me try and do that as efficiently as I can. And in a couple of cases, if I might just give you the paragraph references rather than showing
Yes,
them to you.
certainly.
in the
Yep.
interest of time.
Yes.
But can we start with O'Kelly? So, decision of this court, Volume 1, Tab 10. And these were waiters engaged by Trust House Forte, and they were what was called regular casuals. So they were casual in the sense that they were engaged from engagement to engagement, but they were regular in the sense that they were on a list that could be called upon. Now, the Industrial Tribunal said there was no mutuality of obligation, so therefore they weren't employees. The EAT said they were employees, and this court concluded that they were not employees. So it wasn't appropriate to interfere with the Industrial Tribunal's conclusion. The Court of Appeal split 2-1 in an important respect. So just to note as we pass, counsel for Trust House Forte were Mr. Irvin and Mr. Charlton, page 98, letter D, and letter F at page 100, Mr. Sedley appeared to be applicants. So picking the judgments up at report page 99, page 103 of the bundle, Lord Justice Ackner, who eventually dissents on one point, sets out the facts in those first couple of paragraphs about the list and the casuals and their regular engagement. And because they were known as regulars, they had an assurance of priority allocation. That's a letter F at page 99. And equally, some of them did not have any other work. So one can see that at letter G on report page 99, they were working 40 hours a week. Some of them had no other regular employment. And then the facts of Mr. O'Kelly and Mr. Pearman, who were wine butlers, report page 101, letter B. They worked varying hours in a week from 3 hours up to 57. In the last year, they each had only 2 weeks in which they did not work. They averaged 31 hours a week or 42 hours a week. And then report page 105, letter F, it identifies the factors that the Industrial Tribunal considered to be inconsistent with a contract of employment. And at letter O, internal letter O, letter G in the margin, the applicants had the right to decide whether or not to accept work, although whether it would be in their interest to exercise the right to refuse work is another matter. And P, the company had no obligation to provide any work. And then, foot of that page, the majority decision of the Industrial Tribunal was, and then top of the next page, 106 of the report, mutuality was an important agreement, ingredient that was missing. Expectation, but no obligation, purely commercial transaction for the supply and purchase of services for specific events. Because there was no obligation for the company to provide further work and no obligation for the applicants to offer their further services. So against that background, there's a passage in Lord Justice Ackner's document about the jurisdiction. We're not concerned with that, and questions of fact and questions of law and Edwards and Bairstow. Not concerned with that. So picking it up at page 115 of the report, letter G, at the Appeal Tribunal, 2 attacks were mounted upon the decision of the Industrial Tribunal. I will seek to deal with these separately. One was the finding that there's no contractual obligation either on the company to offer work or on the applicants to do work once rostered. And that was submitted to be wrong because there was a regular practice of engagement. The argument was in effect that that regular practice had crystallised into an obligation to offer work. And Lord Justice Ackner rejects that at 116 between letters B to C. He says, I do not think that is right. It's Mr. Sedley's contention. The assurance of preference in the allocation of any available work which the regulars enjoyed was no more than a firm expectation in practice. It was not a contractual promise. So there was no obligation to offer or to accept work. And then the second contention that he addresses was an argument about weighing of the balance of certain factors. I'm not concerned with that. Now, Lord Justice Ackner then goes on at 117 of the report, letter C, to consider whether, if there was no employment mutuality in the overarching agreement, could it be said that there was employment mutuality in the individual contracts? And he would have allowed, he believed the Industrial Tribunal had not addressed that, and he would have allowed that argument to be pursued, so he would have remitted it. And that's at the foot of 118, letter H. He dissents in this because the majority think. So Lord Justice Fox begins at the top of 119. There's some passages dealing with questions of fact, questions of law, Edwards and Bairstow. Picking it up at 121, letter F. He addresses, between letters F and G, the argument as to whether an expectation of work might crystallise into an obligation to offer work and to accept it. He says, no, that's a matter of fact, and that argument is precluded by the conclusions of the Industrial Tribunal. Then he says at letter B at 122 that there remains the question of whether there was a series of individual contracts of employment of the regular casuals. He concludes that in effect the Industrial Tribunal had also decided that matter against Mr. O'Kelly. So he would not have sent it back, he would dismiss the appeal. And then Sir John Donaldson, the Master of the Rolls, he also begins with an analysis of Edwards and Bairstow, matters of fact and matters of law. Picking it up at 124, letter F, he identifies that the arrangement between the parties may have been a promise to offer work and a promise to accept work. He says if that were right, it would have constituted a contract, but that was not necessarily the right characterisation of the relationship. He says at letter G, but what happened in fact could equally well be attributed to market forces. So he thinks, as does the court as a whole, that there was no mutuality in the overarching agreement. And then at 125, letter B, he says this leaves the question of whether the applicants entered into individual contracts of employment, and he concludes that they did not. The Industrial Tribunal had decided that they did.
So this authority doesn't really help us with the characteristics that are necessary for individuals, precisely because the Court of Appeal, the majority of the Court of Appeal, saw a rather cursory sentence, which we see at page 122E, as a sufficient finding by the Industrial Tribunal that there weren't individual contracts of employment.
Believe that's the effect of this.
So there's no discussion of that question by the Court of Appeal. What the Court of Appeal is saying is that was a sufficient consideration by the IT of that question.
Malay, that is right, but the significance of this case is that the concept of mutuality that was being applied by the court is that set out by Lord Justice Ackno, crisply at 106, letter B. As an obligation to provide work and an obligation to accept work.
But I mean, he does, just going back to the discussion we had a while earlier, I mean, he talks about no obligation to offer them to provide further work. So I assume what he means by that, no obligation to provide them another night's work at another banquet, not the night's work.
And also, he's not convinced that the IT focused on this issue at all, so he would have remitted it on this question.
He would have remitted it. Related, the concept of mutuality that the court is applying here is the same. It is that notion of obligation to offer work and obligation to accept work.
Oh, I see. No, I think I'm wrong because I mean, I've read what he. So, what he's saying at B, it was purely as specific ones, no obligation to provide.
That's in the concept of the alleged overarching.
So there's no, what he means by that, there's no overarching contract to continue to provide further work. So one is then left with the individual engagements on a night-by-night basis.
Yes, which he, Lord Justice Ackner, would have sent back because he didn't think the Industrial Tribunal had decided, and the majority thought they had. But then, turning on in the authorities bundle to tab 15, Clark. This is a bank nurse case. Mrs. Clark worked for the Oxfordshire Health Authority's nurse bank as a staff nurse. That's the first few lines of the left-hand column of the facts. And when she did work, first whole punch, she was paid an hourly rate on the basis of the Whitley Council scale. And then just above the second whole punch, left-hand column, an industrial tribunal concluded that Mrs. Clark worked for the nurse bank on a casual basis. She was not an employee, and therefore could not pursue a claim for unfair dismissal. And then an inch below the second whole punch, on appeal, the EAT held the lack of mutuality of obligation was a significant factor that must be seen in the context of the other terms and conditions. And the EAT concluded that there was a global contract of employment. And the Court of Appeal disagreed and remitted the case to the Industrial Tribunal. So the ET had said she wasn't an employee, the EAT said she was, the Court of Appeal said that she wasn't, but remitted it to the Employment Tribunal. For our purposes, relevantly, paragraph 12, the Industrial Tribunal finds as a fact, this is page 197 of the bundle, left-hand column, the Industrial Tribunal found as a fact that though the applicant said she never refused work, there was no obligation upon her to accept work, nor any obligation on the authority to offer her work. And then the nature of this concept of mutuality is considered in Sir Christopher Slade's judgment of paragraph 22. So in my judgment, two decisions of this court are authority binding on us for the proposition that no contract of employment within the definition contained in the Act, whether it be given the extra statutory name global or umbrella or any other name, can exist in the absence of mutual obligations subsisting over the entire duration of the relevant period. And he then cites from Nethermere, which just for your note is in the first bundle of authorities at tab 11. And can I invite you quickly to read, to save you looking at separately at Nethermere, just look at read paragraph 23.
Right. Yeah.
And then lastly, last page of the tab, paragraph 41, slightly quicker to read there.
But how does this help us? Because Court of Appeal recognised that the Industrial Tribunal hadn't dealt with a specific engagement issue. And that issue was remitted to the Industrial Tribunal.
I'm afraid I didn't catch the question.
Well, I was just asking you, Mr. Peacock, how this case helps us, because the reasoning of the Court of Appeal is addressed to a global contract, and the question whether or not there was a specific engagement which made the bank nurse an employee was remitted to the Industrial Tribunal because they hadn't dealt with it.
Yeah, but I quite accept that, and I'm not suggesting otherwise.
Right.
The significance of this authority is that it's the Court of Appeal seeking to identify what is the nature and scope and role of this mutuality concept.
But against the background of considering whether there's a global contract.
In this case, yes.
Right.
Now, a case we perhaps don't need to turn up, but Mr. Justice Park, in a tax context, a case called Hughes, Tech and Young, identifies the significance and role of mutuality in just the same terms. This is Volume 1, Tab 22. And in particular, it says paragraphs 60 and 64. And again, just for your note, the case of stevedoring, which is in Volume 1, Tab 19, decision of this court, Lord Justice Sheeman, Lord Justice Robert Walker, and Lord Justice Tuckey, paragraphs 10 and 11. Chronologically, the next case of relevance on this part of my argument is Cotswolds, but I've shown you that one, so I just invite you at this stage again to look at Cotswolds, Volume 1, Tab 23, and here again, just for your note, the relevant paragraphs are 19 to 20, 40, 47 to 48, and 54 to 58. And then Volume 2, this is the Quashie case, Volume 2, Tab 34. This is the dancer bringing a claim against Stringfellows. Lord Justice Elias, page 449 of the bundle begins in that right-hand column. And then can I invite you to note paragraphs 6 and 7. can I invite you quickly to read 6, 7 and 8?
I'm so sorry, I've got behind. Which tab again, please, Mr.
We are in tab 34.
Thank you very much.
Miss Lord Justice Elias, initially to read paragraphs 6, 7 and 8. Six, 7 and 8. Now, there are three things interesting and relevant about what His Lordship says here. Firstly, at the end of 6, he describes ready-mixed concrete as a multifactorial test. Secondly, he says at the beginning of paragraph 7 that given the diverse forms of employment relationship, no test will provide a ready universal answer. And then, having set out RMC, in 8 he says, this approach recognises, therefore, that the issue is not simply one of control, and that the nature of the contractual provisions may be inconsistent with the contract being a contract of service.
Well, that's just really a restatement, in other words, of the ready mixed concrete test. You know?
But with this, this emphasis, at least from my point of view, that whether he's whether one adopts the approach of looking at the nature of the contractual provision at stage 1 or at stage 3,
Yes.
you have to do it in one or both of those places.
Absolutely. I mean, that does rather chime with the point I was putting to you probably about an hour ago now, about it doesn't much matter where, at what stage you do it, as long as you don't overlook it.
Yes, and this Lord Justice Rice doesn't quite say, doesn't say it in those terms, but
No.
that is the gist.
That's a paraphrase.
That's the gist of his observation. So then at 10, he has a series of paragraphs dealing with the nature of mutuality of obligation. I think you were shown these by my learned friend. But, and rather than me read them out, if I invite you to read them in due course, it's 10 through to 14. And it's at 14 where he rows back to a degree from what he'd said in Stevenson and Delphi Diesel. And in 14, he's rowing back from the last sentence of paragraph 14 in Stevenson and Delphi Diesel, where he had said that the only question is control.
Yes.
And in 14, he says that's a little sweeping, but it also has to be read in light of what he said in paragraphs 6, 7, and 8. He saw ready mixed as a multifactorial test, no universal answer, and 8, you have to look at the nature of the obligations. But then it's interesting in this case as to what happens when he comes to decide partially. So if one looks on at page, paragraph 42, right-hand column is the heading discussion. He says this in 43, there plainly were mutual obligations of some kind in place when the claimant was actually working. And then he gives some examples. Then in 44 he says, in view of these and other references to the relationship between contractual, I do not think one should attribute to the employment judge the elementary error of concluding that the relationship was not contractual at all. So there was a contract. But in 45 he says, the critical question was as to whether the nature of those contractual obligations. And then reading on, were they such as to render it a contract of employment? And then he harks back to RMC. And in 46 and 47 he concludes that there was not the right sort of contractual obligation as between the dancer and Stringfellows. But then importantly, paragraphs my friend I think didn't take you to, no he didn't take you to, 54 down to 57. 54, I do accept that there were some mutual obligations in play when the dancer was at work. Indeed, she had a duty at least once on the rota to work certain days. I also accept that it can readily be implied that the appellant was under some obligation to allow her to dance when she was at work. Surely it could not have been understood that she would have to pay the tip-out fee and the house fee and yet be prevented from dancing at all. Then in 55, it says it follows, in my judgment, the employment tribunal was fully entitled to conclude that there was no relationship of employer and employee constituted by this arrangement. Although I accept the reasoning of the tribunal with respect to mutualising obligations is not entirely satisfactory, reading the judgment as a whole, I think it is plain why they reached the decision it did, why it reached the decision it did, and that was a conclusion which was reasonably sustainable and consistent with its findings of fact. The analysis in the EAT was premised on the assumption that the mutual obligations of work and wages were established. At the end of 56, but in my judgment, the premise was not open to the EAT in view of the tribunal's findings. 57, moreover, insofar as the EAT was saying that the result would be the same even if the employer was merely providing the dancer an opportunity to present her skills, which is essentially what the tribunal did find, I respectfully disagree. Those mutual obligations would constitute a contract, but they would certainly not compel the conclusion that it was a contract of employment. The analogy with the caddy was, in my view, an apt one. So when he comes to decide this case, he recognises that there was a contract, he recognises that there were obligations of some sort, but he concludes that on the facts of the case, the obligations were not of the right nature to satisfy the notion of a contract of employment. So how he actually comes to decide the case is classic RMC. So what he says in paragraph 14 about the degree of rowing back from what he'd said in Stevenson and Delphi Diesel has, in my submission, to be read in light of how he actually decided this case from 42 through to 57, but also in light of what he'd said in paragraphs 6 through 8. So the upshot of that in our submission is that there are authorities in this court that mutuality requires more than merely a contract and more than merely a contract somewhere in the employment field. It has a stronger meaning requiring you to look to the nature of the obligations on the part of the putative employer and putative employee. And whether analytically one thinks one is doing that at stage 1 or at stage 3 does not matter for my part.
But on the employer's side, I mean, just accepting that premise, on the employer's side, you're looking not only for an obligation to pay, but an obligation to provide the work. Is that what you're saying?
That's what the authorities say, yes.
And where you've got an individual contract, but no overarching contract, I'm sorry, I may have asked you this question, but I mean, the obligation to provide, why isn't the obligation to provide that work under that contract in a sense fulfilled when the offer and acceptance takes place and the contract comes into existence? I mean, if I offer you
The match on Saturday, this match on Saturday, you accept, you make the booking, I accept the booking. We've made a contract for you to do it on Saturday, so I have. I mean, it's a bit unreal to analyse my obligations as I have an obligation to offer you work because I've done it.
Well, Lord, that is absolutely right. You have made the offer, and I have accepted.
yeah. I mean, obviously I've got to pay you for it.
And assuming I do the work, then
Exactly.
you pay me my £320.
Exactly, and the fact that we can both terminate it as a term contract, I don't at the moment see bears on that question. I mean, I know but that seems to me where the issue is here.
Your Lordship's example is assuming that the obligation to offer work is present and demonstrated by the offer itself.
Yes, I'm assuming there's no overarching contract which requires me to offer you work.
You just do.
I just do it. And I ring you up and say, can you referee the match on Saturday? And if so, can you book in or whatever you've got to do? And I accept your booking, so you're doing it on Saturday. I mean, I've offered you the work, you've accepted the work. Well, I mean, what's more to be said on that issue as far as our contract is concerned?
We undoubtedly have a contract
Well, undoubtedly.
by which
you will provide personal services in the form of refereeing the match, and I'll pay you. I mean, let's park control, that's a separate issue, but on the guts of it, if you like, absolutely, without prejudice to what the control position, why isn't there sufficient mutuality in that arrangement?
Because if we're putting aside control and we don't take account of my ability to change my mind and your Lordship's ability to change your mind, if we discount those for now, then we have arrived at a contract that is somewhere in the employment field.
Yeah.
If I'm going to do something for a fee. But the proposition against me is that that is itself necessarily a contract of employment.
Can't be right. I mean, can it, with respect? I mean, because otherwise that would mean stages 2 and 3 of the analysis didn't matter.
No, but Lord, in answer to my Lord's observation, we're putting aside.
But why on earth should one put aside what we know we have to do? I mean, this all seems so artificial. As though we were this is some point of medieval theology we were discussing.
What my Lord Justice Patten was asking you to put aside was the ability to infer by the terms of the contract to either side to pull out once they've been offered an acceptance. I think that's all it was asking you to ask.
I mean, what I'm trying to do, as my lady says, is what I'm trying to do is I'm rowing with you on the basis that when you, I mean, I entirely accept what Lord Justice Henderson said. It's a much more global analysis, but if for purposes of analysis we're following your argument and we're saying that whether you do it globally or you do it sequentially, under the mutuality head, you are looking to identify not merely a contract exists, that contract is for the provision of work personally, but also the minimum obligations on both sides. So you're doing that under the head of mutuality. I don't understand why that requirement, i.e. that the employer should provide work, isn't satisfied by the entry into the contract itself. I mean, I'm asking you this because the Upper Tribunal in the present case seemed to think that you had to find something else beyond the fact that you'd entered into the engagement and there was an obligation to pay you for it. And it's that I'm having difficulty when you haven't got an overarching contract and you have entered into a contract to do the work. I mean, I'm sorry, I can't put it any more.
No, well, I see the question. I see the observation. And my answer is this, that thus far the authorities express mutuality in terms of an obligation on the part of the employer to offer work or pay a retainer in lieu of work, and to pay for work done, and on the part of the employee to, or putative employee, to accept the work and enjoy it. And that works well in an RMC type case where you're looking to characterise a 5-year contract. It's perfectly acceptable test and touchstone when one is asking about an overarching contract. Where you have an overarching contract that doesn't have those obligations, but a series of individual engagements that you are then attempting to test the nature of, your Lordship says with force I might respectfully say so, that well, in those circumstances, you're not looking for some theoretical obligation to offer the work, which would be somehow just outside the individual engagement. You're only looking at the fact of the offer, and then the acceptance. I understand, I accept that. And there's nothing in the authorities that tackles that crisp example, save for the bit in Windle that we looked at, which says that in gauging the nature of the obligations in an individual engagement case, it can be relevant to take account of the lack of the obligation to offer work in overarching. Now, in the present case, that's what this First Tier Tribunal do. So they weigh that factor in as bearing on the nature of the obligations. And they also weigh in the balance the fact they regard it as dictative in as do I, that even in the agreement that your Lordship and I arrived at, your Lordship is free to say, I've changed my mind.
Yeah.
And I am free to say, for whatever reason, I'm afraid I'm just not now going to do this. And those factors are material, I say, in determining the nature of the obligation, even where it is an offer of a match which is then accepted on Tuesday. But maybe this is to state the obvious, there is no authority that looks exactly at the point your Lordship's question raises. But equally, none of the authorities that my friend has relied upon thus far answer this case. Indeed, they don't support the proposition that he would have you accept. And perhaps if I deal with as swiftly as I can the cases that you heard from a learned friend about. McMeechan, and we ought to turn up McMeechan because it's really the foundation of this case. It's in volume 1 of the authorities, tab 14. So it's an agency case. he was engaged by an agency who in effect provided his services to a client for a series of temporary contracts. And the agency became insolvent, so he made an application under the statute for sums that were owed to him by the agency, and he was refused on the basis that he wasn't an employee of the agency. So the Industrial Tribunal said that Mr. McMeechan wasn't an employee. The EAT said that he was an employee. The Secretary of State appealed, and this court decided that he was an employee in this case. Now, the way the argument was put was necessarily a little unsatisfactory because Mr. McMeechan was representing himself. He was appearing in person, and that appears from 551 in the report. And ultimately, the court comes to address one particular short-term engagement of his where he was seeking an amount of £105.07, which is at letter D on 551. But it's relevant to note, page 553, that one of the terms of the contract that he signed with the agent, clause 5, at letter C, you are under no obligation to accept any offer made under paragraph 3, so an offer of work, but if you do so, you are required to fulfil the normal common law duties which an employee would do to an employer, as far as they are applicable. In addition, you will at all times when services are performed for a client comply with the following conditions, and then they will then set out. And then at 6, letter G, the contractor is not obliged to provide and you are not required to serve any particular number of hours during any day or week. But in the event of your declining to accept any offer of work or failing to attend work for any reason, for any period, this contract shall terminate. So clause 5 imposed on him full employee duties if he accepted work. And then reading on at 555, this court, Lord Justice Waite, heading the law, refers to O'Kelly and Trust House 40, and he takes from that a direction to consider all aspects of the relationship, etc. And then he refers to Harvey on industrial relations and employment law. And then at G, the principle which is enshrined is that if there be an absence on one side of any obligation to provide work and an absence on the other side of any obligation to do such work as may voluntarily be provided, then that provides a powerful pointer against the contract being one of service. And then over the page, he tests the general engagement. Was there an overarching contract? And then over the page again at 557 is a heading, the specific engagement. And he accurately records between letters D and F that in O'Kelly, this court had concluded on the majority that there was no mutuality in those specific contracts, those specific engagements. And then turning on 559, proceedings in the Industrial Tribunal, Mr. McMeechan had said there that he was working under a general or umbrella contract. And that's between letters C and D at 559. And he lost that argument in the Industrial Tribunal on the basis that there wasn't mutuality of obligation. And in the EAT, over the page at 560, again the argument was in terms of the overarching contract, general engagement. And then at 561, the argument in the Court of Appeal and the applicant's argument in the Court of Appeal, firstly, was to repeat that he was employed under a general engagement. That's 562 letter D. But then at letter E, His Lordship says, as the argument proceeded, it appeared to the members of this court the relief for which the applicant was really and primarily asking was to be treated as an employee of the contractor in respect of the stint that he served with their client, Sutcliffe Catering. So this appeared in the argument in the Court of Appeal that his real complaint was a complaint about the specific engagement. And so they allowed that argument to be considered. We could go back and say Lord Meston, who was appearing for the Secretary of State, ran a series of arguments that were enumerated at letter F. Firstly, the specific engagement can't be severed from the general engagement, one. And then at letter G, even if one is not right, conditions govern both the general and the specific engagement, and therefore Mr. McNewton couldn't get home. And then 3 at letter H, if 1 and 2 are not right, then the absence of mutuality of obligation to provide work or to do it is still relevant and fatally so for the purpose of construing the terms of business. And that's what caused this court at 563, under the heading the single engagement claim, is it maintainable at all? The court concludes yes. And then over the page at 564, heading at the foot of the page, the merits of the single engagement claim. And it's these passages I think you've seen from the learned friend. So at the foot of 192, they begin with the merits of the single engagement claim. They say, in addressing that, that is a question, foot of the page, though it remains essentially one of fact and degree, and in Cross House 40, is one which largely falls to be determined on the interpretation of the conditions. And then they deal with condition 5, saying that that suggests a contract of service, it's an importing of common law duties. And then they say in subparagraph 2 at letter C on 565, the conditions 3, 6, 9 and the first sentence of 5 excluding mutuality of obligations are irrelevant in this context. So excluding mutuality of obligation under the general engagement is not relevant to the specific engagement, and one needs to mark there in the margin that's no longer true in light of Windle.
Sorry, no longer true in the light of
Windle.
Windle, thank you.
Sorry, what's no longer true in the light of Windle?
The point that's made by Lord Justice Waite at subparagraph 2, 193 letter C, where he's dealing with the exclusion of mutuality of obligation under the general engagement. He's saying that's not relevant in the context of the individual engagement.
No, but his point must be right, mustn't it? That in the where he says in the circumstances of specific engagement, there's nothing on which they can operate.
That's right.
And this is the point. I'm not going to go back there, but that's the point we've just been discussing.
Well, he's right about that.
Yeah.
But the suggestion that it has the absence here has no significance here is not now orthodox. And then what they do in subparagraph 3 is to weigh the conditions in the way that the law requires. So it's a weighing up exercise, bearing in mind the nature of the obligations imposed upon Mr. McMeechan if he did accept the gig. And that's in particular clause 5, he accepted all the common law duties of an employee. That's what leads the judge to say at 4, the general impression which emerges is the engagement involved in a single assignment gave rise, despite the label appointed by the parties, to a contract of service. So Mr. McMeechan was entitled to claim his £105.07 for the contract with Sutton Catering, because once the common law duties of an employee were imported into that engagement, looking at all the facts in the round, he was to be seen as an employee. But McMeechan doesn't establish anything more than that. It tells you sometimes you may have to look at an umbrella agreement, sometimes you may have to look at individual agreements. It tells you an employee can get home on the individual agreements, and it tells you why Mr. McMeechan got home, because the common law duties of an employee were imported by contract. But it doesn't tell you anything else about the nature of the present debate. And it's interesting to note, I didn't actually read it, but Lord Justice Waite cites from Harvey, that then stood at letter G 563, the better view is not whether the casual worker is obliged to turn up for or to do the work, but rather if he turns up for and does the work, whether he does so under a contract of service or for services. That's making the point that the fact that you do turn up and work doesn't necessarily make you an employee. My friend relied on Byrne Brothers. If I just invite you to read paragraphs 10, volume 1, tab 20, invite you to read paragraphs 10, 13, 25 and 26. And there's nothing here in the observations of Mr. Recorder Underhill inconsistent with the submission I'm making to the court. He doesn't address the concept of mutuality as a matter of principle. Stevenson and Delphi Diesel, volume 1, tab 21, that's the tripartite contract case, where the question was there a contract at all? So you can see why there the focus is on mutuality establishing a contract at all. But the judge there is not saying that mutuality merely requires a contract, or is merely relevant to the determination of the contract. He is, on close analysis, just answering the fact pattern of that case, and where he puts the matter too high, he rose back, as we saw a little earlier.
Yeah.
So the paragraphs you were shown in Stevenson and Delphi Diesel need to be read in light of the other authorities, and in particular, Mr. Justice Elias is rowing back.
Is that a convenient moment, or are we getting to a breaking point, and it's now just after 1 o'clock?
My Lord, that would be. I'm afraid it has taken me longer than I had anticipated, but with a bit of judicious speeding up, I would aim to be done by 3.
That should allow Mr. Nordat ample time. Yeah, good. Thank you very much. In that case, we'll continue at 2 o'clock.